Hi everyone, this is Sean. Welcome back to our channel. Please press the thumbs up button, subscribe, share, and comment. In today's video, we are going to be talking about how to write a contract. This is just basic contract formation. If you are a line staff officer, meaning you're not a manager, you are the security member of the team who makes everything happen on a day-to-day level, you will most likely benefit from this video towards the second part when we talk about special relationships, but I still want you to watch the video from the beginning. If you own a security company, you're involved in contracts, maybe you're the manager of the security company, the entire video is going to benefit you. What I say in this video is not legal advice, is not professional advice. I might use the terms legal, required, agreement, legal, binding, even though it sounds like attorney-ish, so to speak. I'm not an attorney. The information in this video is just personal tips that I have for you from not being an attorney. Make sure that you gather all the information that you collect today, write notes, and have a discussion with your attorney. So, for the basic contract formation, you need what's called Q-tips. Q-tips. Q-tips, it kind of sort of looks like something that you put in your ear, which you're not actually supposed to do. Ladies use it for makeup. It's cotton on one end, and then there's a stick where that cotton attaches to. Q-tips. The Q stands for quantity. How many hours of service or minutes will you be providing to the client? Quantity. T. Okay. The T stands for time. Is this 10 hours a week, 10 hours a month? That's the time period. And when does this contract begin? The 1st of March to the end of December? You have to be specific on the time periods and also the time for performance. When I say time for performance, I'm referring to 10 hours a week, 1 hour a week. Okay, the actual time. The I is for involved parties. Who is the involved parties? Most of the time, it's a security company, and then it's the other party is going to be the client. Sometimes you can have a third party and a fourth party to agreements. It gets a little bit more complicated, but you have to identify who the parties are in the contract. P. Okay, P. This is price. So you are going to charge how much an hour? $10 an hour, $20 an hour, $50 an hour, $60 an hour. You have to be specific on your price. And last but not least is subject. Q-tips. At the end is the S. Subject refers to the type of service or level of service that you will be performing. Is this guard patrol? Is this DTEX patrol? Is this foot patrol? Are they going to be checking the entrances and exits? Are they going to be checking everybody by using a metal detector device? That's where you get specific. So a basic contract has Q-tips. Here's some other things that you need in order for a contract to be legally binding. You need a meeting of the minds. All parties to the agreement have to agree to the terms and conditions of the agreement. If there's some type of confusion in the agreement, one person doesn't understand, you don't have a meeting of the minds. And you don't have a contract, you don't have a legally binding agreement unless you have the meeting of the minds. And then last but not least, you have to have what's called consideration. Most of the time, this means that there's some type of a payment. Like you're accepting in exchange for you providing service, some type of payment. Okay. If there is no consideration, okay, this for that, you probably don't even have a legal binding agreement. So what do you need in order to write a contract that meets the minimum standards? You need Q-tips. Quantity, time, involved parties, the price, and the subject matter. And then there's two things that you need. Where are they? And I'm asking you. Meeting of the minds and then you need what's called consideration. This for that. In exchange for this agreement, what is somebody receiving? Those are the conditions. Now, this is something that I just picked up. And thank you for one of our subscribers. I won't mention his name, but he sent me a proposal for security services from a fairly large or decent sized security company. And what shocked me is that that security company offered to prevent loss, misuse, or destruction of property. Prevent loss, misuse, and destruction of property. That was in the proposal. Now, you might argue and say that's not the contract. Well, many times proposals, most of the terms on a proposal, depending on the client, they're accepted into the last and final agreement, which is the contract. The client wants for you to contract with him or her because they like the proposal. So in this proposal, that's what it says. Now, what's the problem with writing down or proposing that you're going to prevent loss, destruction, misuse of property? That's almost impossible. Let me give you a scenario. You are contracted to protect, we'll say, Juan Pollo's chicken, okay? And there's an employee that was given the boot. And this is, by the way, a corporate office. So that employee one day, bypasses your security officer. That security officer still thinks or forgot to check the memo that this person no longer allowed on the premises. The employee goes to the computer, says hi to a couple of people who don't know he's fired, and gets some trade secrets, gets the secret recipe for Juan Pollo. This person sells a recipe to El Pollo Loco Chicken. Now, what do you have? Well, you basically have theft of trade secrets. A trade secret would probably be classified as intellectual property. Well, in your contract, you specified as a term and condition that you will prevent loss, destruction of property. And the word property is such a broad term that it would encompass intellectual property. You see what I mean here? That security company, who's fairly large, they just agreed to do something impossible. And it's no wonder that many clients would probably accept that service because, hey, I don't have to be responsible if there is some type of loss or damage to property. We'll just hold a security company responsible because they wrote in the contract that we're going to prevent that from happening. That's impossible, guys. And just imagine that you're contracted to protect a large building that has valuable assets, and there's obviously people in there, and a terrorist goes in there with a U-Haul trailer, blows up the building. But before that, he runs over the security officer. Security officer can't prevent that person from entering. Security officer is killed in line of duty. Who would be responsible here? Security company. And why is that? Because the security company agreed to prevent loss, destruction, misuse of property. Okay, the property, obviously lives were destroyed. Now, I can't criticize the loss of life because this security company that I reviewed didn't write that into the terms and conditions. They didn't say that they're going to prevent loss of life. They said prevent loss of property. So if there's a lawsuit, it'll be against the security company for not providing adequate security coverage because they were supposed to prevent that. They even stated that was a reason why we contracted with a security company because they agreed to prevent loss, destruction, misuse of property, and they didn't do that. One would argue the security officer was killed in line of duty. That's devastating. That's horrible. But if you take away the sentiment, the contract was breached. Okay, you had a breach of agreement. And that breach, I would argue, is a material breach. That term and condition was instrumental for both parties on agreeing to the terms and conditions. So you probably have a material breach. Security company's going to pay. And then now what you have is something called negligence. Okay, that's negligence. Negligence is a cause of action in civil court under civil law. Now, whoever is damaged or affected by the negligence of the security company can sue the security company directly, not for the loss of life not for the loss of life term and condition on the policy, but for the assertion that they're going to prevent loss, damage, misuse of property, and they failed to do that. As a result, you have people that are injured. Now, there's also something called a special relationship doctrine. And we saw that happen, I think it's Douglas High School in Florida, when you have the student resource officer that didn't take action and a lot of lives were destroyed. Kids were murdered by the active killer incident. The deputy, as far as I can remember, was criminally charged for child endangerment. And why is that? Because the district attorney pushed the special relationship issue. That SRO was contracted to protect the children. Whereas the officers arriving at the scene, or deputies arriving at the scene, didn't have a duty of care to the students. It was that student resource officer who was on a separate contract who was responsible. Just think about if you're a security officer on contract at a school. If your employer agrees to protect, children from active shooters or active killer incidents, if you write into the agreement, if you're a security officer and you take off and you don't do your share of the bargain, I can easily see a prosecutor pushing for child endangerment. And I think that they'll get past the probable cause hearing. I really do. Maybe even a grand jury indictment. I absolutely see that happening nowadays. Now, you're a security officer and you're saying, wait a minute, I have to stay? I didn't sign up for this. That depends on the policy. Did your employer give you a policy? Did your employer give you post orders? And did you agree to those post orders? Most of the time, your employers will have you sign. If it says there that you will protect staff, visitors, employees, vendors from hostile individuals, well, that's what it exactly means. It means that you don't run away. It means that you stay there. Now, I think it's going to hit you if it's children involved, because again, it goes back to public sentiment. You just don't leave any post if you sign up for this, ladies and gentlemen. Something to think about. Special relationships. You got to be really, really careful, those of you who are writing these contracts. What you write in these contracts has an effect on the security officers assigned to these posts. Guys and gals, if you like this content, remember, I have created a 40-hour private patrol operator leadership and development course. We talk about proposals, contracts, how to get bids, bidding analysis, how to look up what other companies are bidding, what they offer. We have about a 3.5-hour module just on that. And there's also a contract template that I have created for you. It's a small one, though. I think it's a half a page or a page. It might be 2 pages, but just something simple. If somebody needed your services today and it wasn't too complicated, maybe they only need your services for a whole day and that's it. I think the contract might be sufficient. I mean, it does meet the Q-tips element of contract law, but it's something simple. And it's something that you can build your foundation off of. You can actually bring that to a licensed attorney and see, hey, does this fit our current fact pattern? Now, I don't sell that contract individually. It comes with the course. So I can't just give you a piece of paper and then you expect to fill your name on it, the client's name on it. You have to be educated on how contracts are created, what you should put on the form, and how you should modify it yourself. Okay? So that's part of the 40-hour course. Those of you who are already enrolled in the course, a lot of this information that we discussed today is a review. If you're interested in the course, I'll leave a link in the description box below. That course will help you pass the qualified manager exam in California. Remember, if Assembly Bill 1244 passes, then you're going to have very limited time in order to become a qualified manager. 90% of you watching this video would not be able to qualify because you have to have 1 year of managerial or administrative experience under a current and licensed private patrol operator. Almost nobody has that experience. That's all I have today. If you have any questions, concerns, I'm looking forward to feedback. Take care, guys.